prayer for requisition in item 16, my lord. I filed one additional affidavit, my lord. Item 16, bail application. My lord, one more prayer, my lord. I filed one IA in item number 18, my lord. IA criminal, my lord. That may also kindly be allowed.
What is the right?
My lord, IA is for my lord. We have got one case, my lord. So here before he said IO, my lord, he had refused to record our statement, my lord. Today, item 16 and 18.
Lordship, may I beg to mention one criminal petition pending matter, this urgent matter, matter may be fixed for tomorrow. Because one matter is already in a connected matter has been already issued notice. So, yes. And one more mention, item number 28. This matter also may be posted for tomorrow. This is Majumdar matter, Dilip Majumdar matter. 28. Yes, 20. No, no interim issue. No, this is item number 28 is not that. This is civil matter.
CRP, my lord.
CRP.
28, my lord.
28. This civil matter. That, yes, that,
27, 28.
yes,
Together.
yes, together.
Not become some other day. Prepare of the conflict for the parties and the rest of the
27
Go to him,
28 is, I think, not connected. 27 is not connected. 20.
27. The party is also not here.
Yes.
Yes, my lord. He will be here tomorrow.
Particular date may be fixed, Lordship. Can this matter be fixed on Monday? Monday. 9.
May I please, my lord? My lord, I would like to mention one pending criminal petition, my lord.
My lord, I'm praying for listing of the matter tomorrow, my lord. My lord, on 30, 2 matters were heard, similar matters. One of the matter was left out, my lord. Therefore, my lord, that it is listed for tomorrow for disposal. Two other matters, service matters, my lord. Yes, my lord. Conclude.
Number one, madam, we have got to recognize. I'll please sit on. I'll deliver the order. Delivery of order in basically to the target on for delivery.
Yes, lordship.
I'm on behalf of respondent. 2 and 3. No. No. He is currently out of station.
Yes, lord. Yes, lord. Absolutely no, your lordship. Your lordship, in fact, we had also prayed for amendment of the petition in one of the application, your lordship. But since the court was not sitting, your lordship has seen that the mobile court was never sitting, your lordship, for a very, now it's sitting, your lordship. However, your lordship, yes. That can also be. Yes, Lord.
That also touches on this.
Absolutely, Lord.
Touches on this issue.
Yes.
And then the observations that have been made are somewhat indicative of your plea.
Yes,
But that was not addressed. I don't want to put him through a judicial position, but I was going through,
yes, Your Lord.
these two issues came to me.
Yes, Your Lord.
So what to do?
Your Lordship, in that case, may give me a liberty to amend my plaint before the trial court, Your Lordship. Yeah, absolutely. Your Lordship may fix the matter
Tomorrow, okay.
tomorrow, Your Lordship. Yes, Your Lordship.
Although the matter was. It's necessary for delivery of this. Come on. This thinking class. About the thinking, but for the very, very by the school, as on that, she would make further clarification. Of the submission. And when you raise it with this matter.
Deeply okay.
Raise issues.
Yes, yes, Your Lordship.
Just the
Yes, yes, Your Lordship. Deeply okay.
Deeply obliged.
May I please? Lordship, kindly pass about this matter. Deeply.
Lordship. My attendant number is 3. Can I get? Yes.
okay, we'll raise it.
Yeah, but can it kindly give some time actually? Just I have to explain. Yes.
Yes.
Yes, Lordship. Only charge sheet is already filed, Lordship. Yes, Lordship. So kindly call for the reports. Lordship.
TCR may be called for lordship.
When did arrest?
Lordship.
On 2nd of
2nd April, Lordship.
On the date of the affair,
Lordship.
the person.
Lordship, can it be fixed on 6th of? Day after tomorrow.
No, not possible, not possible. Next week, lordship. Any date.
Not with the scan copy. Right, copy.
Deeply.
May I please? Yes. This is a bail application filed under section 483 of BNSS, claiming for the enlargement of an alleged accused person. Yes.
The investigation still people are required to be found out. So this is what should we assume?
Lordship,
So that's.
Yes. Reason they are also given.
Now. What the investigating officers are ready, they come some record. Okay.
Lordship,
Yes.
kindly Lordship, a solid may be given. Can it be on 11th of June? Or 12 or 13, Your Lordship.
Well,
Yes. Lordship, one more prayer. Here, in the cost list, my name has been reflected in the respondent side by mistake by the registry officer. Yes, yes.
In the name of the council, which will be reflected as the council of the in the causes on the next page.
Much obliged.
obliged.
Yes. Well, here in this case, FIR, so far as sections are concerned, no sections is like attracted against me. Despite of that, my lord. FIR 20. Twenty-eight five, my lord. Page 17, my lord. That is zero FIR that was lodged by my parents, my lord. Against them. Basically, my lord, allegation is that I had been with this co-accused. Married at her. We have to now become arbitrary for the city.
Yes, exactly, Your Lordship.
Step up the BPS case number, PS case number, 942 List of under sections, 316, 85, 85, 81, of which 3, RP and arising. This case also registered basic. By one, now as informed. A pivotal of the extent of mind that the issues involved raised the allegations against the matrimonial disputes existing in other extremely important and understand with the involvement of the African media. In view of the allegation set out in the FIR, this court of the considered that the custodial interrogation of the African may not be followed. Accordingly, that the African be passed on to the in view of the
Assam is. File your list.
Your Lordship, dispose of or, okay, Your Lordship. Yes, that much, yes, Lordship. Oblige, Your Lordship.
Yes, they've already filed the affidavit. Oblige.
Next time, if there are towers in different places, we will be told.
Alright.
This was.
May I, Your Lordship? Your Lordship, this application is filed under section 528 of BNSS. Yes, Your Lordship. Yes. Socially and legally not married. What, Your Lordship, your record? Kim Bang. Twenty-eight four. Your Lordship, matter may be stated in the court below. Your Lordship, if this interim continues and the proceeding in the main matter continues, it will. Yes.
I will. As well as we will. You take this, steps, come back next time, then you come, we follow.
Yes. Oblige, Your Lordship.
Yes.
My Lordship. Lordship, I have agreed by the FIR dated 26/4/2024, Lordship, Annexure 7. Basically, Your Honor, this case is pertain to civil dispute, Lordship, between the family members, Lordship. My Lordship. FIR is at Lordship, page 45 and 46, is type of it. For criminal trespass and violation of the cover and executive orders, Lordship. 45, Lordship.
Yes.
Yes, Your Lordship, in fact, notice may be issued in this matter. Otherwise, also, Your Lordship, the land is itself in dispute before the appropriate courts, Your Lordship.
Yes, yes. Civil court, civil judge. Yes, yes.
Also before, the-
Aid interim has already been granted, Lordship.
also in this.
Yes, yes, yes.
Your Lordship, at page number
Next,
47,
Annexure 11, page 59, Lordship. Page 66, Lordship. Come here, Lordship. On the strength of FIR, Lordship, the has interfered and causing loss. L1, Lordship.
Page 40, Your Lordship.
The date of this FIR, 26.
26-4, Lordship.
By the. The dispute relating to a proper plan between the party, completion and which other wasn't going to spend it. Before the senior university and in this case, number of impact and adding also very favor of the additional. This point of consideration that this has very to be acquired. It's primary case, civil dispute between this one between you and the law.
Kamba PS, Lordship. PS case number 5 of 32. Kamba, Lordship. Kamba.
Kamba, Your Lordship.
It is in West Siang, Lordship.
Read.
Yes, Lordship. Interim, Lordship, at phase 90, Lordship. Yes, Lordship.
Yes, yes, there is a mistake in you. Number is case number 5 of 2024. Rest of the section. 247, 11,
Your Lordship, in that CD may be called for, Your Lordship. Because just for the formal. Yes. Deeply.
Okay.
That's the comment. What is the instruction?
The concerned officer is also not seen, my lord. He is paying some more time, my lord, for giving proper instruction, my lord. Right, my lord. My lord. Right, my lord. Instruction, my lord, will be only about his authority to, my lord, the issue disorder now. Obviously.
If before my fingerprint starts lordship. Yeah, lordship, what they are checking is the questioning of the notifications reserved for us, lordship. Yes, Honorable Supreme Court lordship order. Lordship, any reduction lordship, it's not permission without leave of the court. So that difficulty is there, lordship.
So, what is your grievance?
No, my grievance is that, my lord. The Supreme Court judgment and order is affected to the reserve forest when it was legally declared. In Incentive Section 4, Section 5 of Assam Forest Regulation, Assam Forest Manual is complied. Then after completion of the
Lordship, Lordship, it was done way back 1973, Lordship. Some sort of preliminary notification. 1976, Lordship. That's on the challenge.
no, no, yes, my lord. What I want to say, my submission is, my submission here in the case is that no the notification was issued. It was issued when there was no Arunachal. It was did in Nepal, and office was at Delhi and Chillon. They have issued preliminary notification. Whether in compliance with notification, whether there was any public hearing or not.
How is the revision?
And at very relevant point of time, there is no communication. But we are staying in that village from generation to generation. So what my contention is that the Supreme Court ruling and order will imply.
Whether it's a legal thing done in terms of the forest, some forest.
Yes,
We will consider. Feelings are complete. But this, body, senior council, very body, and also discuss something, senior government, hearing for the state along with this.
Lordship, I'm appearing on behalf of the SPL for respondent 1 and 2.
What is your name?
Yasmin Rao.
Fix in those basically from this matter for here and where. But is your
that no. Monday.
Yes.
Then
Forest.
Tuesday. Then
11, Lordship.
then I don't want to be a decision. Hearing is 2-0.
That's it then.
Good.
good.
Well, may I please, Your Lordship? In fact, in this matter, This matter is related to the compassionate appointment. In fact, pleading is not complete, but then your lordship was ready to dispose of the matter, and then. All right. Of India, yes.
But this is also a condition, this is under the Administrative Act.
Yes.
You have to pay it to the Assembly.
Okay.
I will commit you to it. That objection I am ignoring how this compassionate appointment, your father died in after 23 years.
No,
Why should there be a compassion?
no, my lord. My father died in 2002. He applied for that. It was not considered. And then in 2000,
Delay on your part in pursuing the application and delay on their part in considering
correct,
the
yes.
and pass. No simple.
My lord, in two,
Most will take given to some person in the report.
yes. My lord, in fact,
Not this time, it's you.
sorry. Well, in fact, his father died in 2002. He filed an application.
I mean, he's been a victim of this order for me.
I think,
These are the- anything you say,
no, in case of father, he died in 2002. His case was not considered. But then after death of his mother, your lordship, he applied fresh. His mother died in 2000. Application was in 2002 only after filing
find another application.
Up. after date of mother. say. Yes, that is the available. But then he was not considered.
After use of life before we tribunal and not this. Because in your yeah, I'm giving you so now this is.
Then I think
What is I mean,
geological survey. Uh, right. Then I think before the then on that ground it can be disposed of.
Survey of India. Against the post, the survey of India, national economics, and they say the maintenance to voting, jurisdictions and business to crime as the court of process, Mr. Mark, something like that. He folks, the appropriate for the victims along with the where it's about people that they not for the responsibility. View of the above, the present situation and the grounded role and the bigger. You make a sense.
Obliged, yes. Obliged. Well, Lordship, this is a bill application filed by the younger brother of this accused person, Teni Baja.
No, Lordship, not yet, Lordship.
Notice has been served to the respondent number 2. was served on the 2 days after the order. It is almost 16 days. And Lordship, this case is charge sheeted, already charge sheeted. And yes, and the accused person, they will appear on the 1st June. No, Lordship, this accused person, they are mother and father, husband, wife, and they are in the custody almost for 50 days in the custody. And Lordship, this accused person, they are suffering from this hepatitis B. This disease is communicable disease. So it is unsafe for the accused person in the custody, which may be harmful to the other prisoners. Yes, Lordship, I have filed this same bail application before this additional session court Basel. Thereafter, this yes. No, Lordship, this bail is pending before this honorable court for the almost 14 days. So, Lordship, now this Lordship, kindly this bail grant to the accused person because this
Lordship is, charge sheet already been submitted, Lordship, and as per the charge sheet, there is material against that, both the accusers, Lordship. No, Lordship, not yet begin. No, Lordship. It's a very, initial stage, Lordship.
Lordship, this accused person, they have to appear before this additional session court Basel on the 9th of this month. So they will appear. So suitable bond. Lordship, this I payment this honor for this this accused may release on with suitable bail bond, and they will appear on the 9th of this month. And Lordship, this accused person, they have 2 children. After the accused person in the custody of this in the custody, they are suffering because now the admission is going on for this children's. Now one accused this children is in 12th fast, one is 7th. So the release of accused person is much necessary.
This is from CGM, Lordship, where the charge sheet has been submitted, Lordship, and they have, yes, Lordship.
How long have you been in custody?
Also almost now 55 days. He was arrested on the 15th of April 2025. Now charged on.
They have not come in the Lordship. For the default bail also not been Lordship here, attracted Lordship, and yes, Lordship.
Yes, okay.
Things have been brought on record.
Lordship, if the, because this is a charge is serious in offense, Lordship, and Lordship, yes, Lordship.
Yes, one this Supreme Court. Yes, you know.
I have got, yes, Lordship, I have got to the charge sheet, Lordship. In the charge sheet, Lordship, it is stated even that both the co-accused has admitted that Lordship. Victim, Lordship, one victim, the victim already died, Lordship. Yes, Lordship.
Yes.
That's why, Lordship, this 103, Lordship, it is lately it is added, Lordship. During the filing of charge sheet, it was added, Lordship.
Yeah, Lordship, this accused person were nowhere they were involved in this incident. And Lordship, this in the affair also the accused person's name is not reflected. They were arrested as a presumption.
The German is appear before the trial.
Lordship, kindly this bail may be granted with a suitable bail bond, and I will appear the next court. And the Lordship, the custody of the accused person may be. No, Lordship. Yeah, I will appear on this the 9th of this. No, Lordship, I was nowhere involved in the incident because my boy who is in the juvenile,
That time I was trying to save my son, and I was nobody involved in the incident because that boy, yes, yeah, Lordship, I'm unemployed. Yes, and now after arrest, being custody in the custody in the jail, my children are suffering. They need the immediate school admission and help here now. Also, kindly this bail may be grant to the accused person with suitable bond amount, and I will appear before this additional session court Basar on the 9th of this month for the trial. No, Lordship, I was never involved in the case. This
Lordship, material lordship, in the lordship, charge sheet lordship. Here lordship, may I lordship, on the basis of the statement of co-accused Jotin Gapak and other several circumstantial evidence, I arrested both the co-accused, which is Tani Baja and that Srimati Anik Baja, finding sufficient incriminating evidence of their involvement in the case. On for their arrest, I had recorded statement of both the accused. In their statement, both had confessed that on receipt of the information from Ms. Yani Mutem, that their son, Mr. Which is Diji's lordship, Tamo Baja was being heard by Diji. Both arrested. Yes, lordship.
Tani Baja.
There's two bail applications. Lordship. One is another lordship, his wife lordship. That the both of them lordship, they are the parents of the Diji's boy lordship, CCL. During that lordship, that incident was occurred lordship between that three boys lordship.
Yes, 3 boys.
And in the lordship, in the meantime, lordship, one girl was informed about the case. Lordship. Yes, lordship.
Yes.
Obliged.
Much better.
Lordship, I have gone through the records of the trial court, Your Lordship. The statement recorded under 183 is not there in the record, Your Lordship.
My lord, agent today, my lord, petitioner behind the custody for 76 days, my lord. Moreover, my lord, yes, my lord, that is fine. No, that is not adequate, my lord. For video call, my lord, the petitioner before lordship, my lord, has gone through the head talks of video conference, my lord. His health condition is more deteriorated. Moreover, my lord,
The victim, Your Lordship. Statement of rest of the witnesses
my lord, another
is present only the 183, Your Lordship. The recorded, Your Lordship. It's not
my
there.
lord, mandatory provision of 47 of the BNSS, my lord, that ground of arrest, my lord, that was not communicated to the petitioner, my lord. I will rely on, even then, my lord, in Bihan Kumar, my lord, it's specific, my lord, even charge sheet is filed, my lord, it should have followed, my lord. In Bihan Kumar's case, my lord. My lord, this is, my lord, concocted chart, my lord. Can you see the FIR, my lord? If your lordship go through the FIR, my lord, the incident took place, my lord, alleged incident took place on 6th September, my lord, of 2024, and FIR was lost on, my lord, 6th of January, 2025, my lord. After 4 months, my lord. My lord, kindly come, there is no explanation on delay part also, my lord, lodging the FIR also. My humble submission, my lord, since I guess provision of 47, my lord, the BNSS is
It's not there, Your Lordship. I have re-verified it. The state.
my lord, 76.
Deeply.
My lord, can I copy with this case report, my lord, Bihan Kumar, my lord. My lord, it is also Bihan Kumar, my lord. Yes, my lord. No, I didn't feel there. But it is there in the Bihan Kumar Valley.
Satisfied that you were given the information. I mean, not the very there is some. Yeah.
There is memo is there. No, there is bill application. Memo of arrest is there. Page 18. 18 on it.
Very clear ground that it was not. May have been communicated to you by.
No, not communicated. Even your lordship may, if the case report is there, there might be there. That is even if it is not pleaded also, it can be a ground, because it violates the Article 22,
Why this with application in the light of that group,
not Bihan Kumar.
in the light of this document, been 17.
Yes, my lord.
You have not said anything about that.
Well, I have, since it is already annexed, it is already annexed, it is already record, Well, it is not, it is not the grounds of arrest, it is just arrest memo,
That is the way it's a-
Yes, Yes, the ground and arrest is essential,
Yes, your lordship, in
Yeah.
fact, he was absconding, your lordship. And only through the CDR and other source of information, your lordship, we could arrest him. With regard to ground of arrest, your lordship, we'll have
Petitioner
to,
face the trial, But once,
yes, your lordship, as per the status report that was submitted before me on the previous occasion, your lordship, the accused was absconding, your lordship. It was only through the only through CDR and W wireless transmission message to both Arunachal and Assam police, your lordship. On later occasion, he was arrested.
ultimately petitioner is arrested,
Deepak.
Obliged,
Right. Yes.
Wait, please, my lord. My lord, the additional affidavit and the IA has not come on record till now. Oh, sorry, my lord, sorry. My lord would kindly have 16 and 18 arise from the same FIR. 16, my lord. Yes, my lord. I was given an interim bail, my lord, in item 18, my lord. Where are? No, my lord. Different persons, my lord.
Brothers.
Brothers, they are brothers, own brothers. 16 is AB. My lord, it is a.
Yes, have you got the-
Yes, city.
Where is the FIR?
My lord would kindly have the FIR, my lord, at page 12, my lord. 12, the complaint is there. FIR, my lord, from page 14 it starts, my lord. This is offense of civil nature, my lord. My lord, yesterday we have made one payment of rupees 50,000, my lord. To the complainant, my lord. I have brought it, my lord. However, it is not on record. I have the printout, my lord. If I may kindly hand it over before the honorable court, my lord.
When were you arrested?
My lord, 12th, my lord. 12th of May, my lord. 23 days, my lord. My lord, I am also undergoing treatment, my lord. The bail applicant, my lord. I am undergoing, my lord, I have some spinal cord problems, my lord. And I am also undergoing electrotherapy, my lord.
What treatment you are undergoing?
My lord, electrotherapy. My lord would kindly have.
What
my-
is that electrotherapy?
My lord, in my body, my lord, that electrotherapy is provided. My lord, may kindly have page 26, my lord. Of item
26 of?
26, my of the BA, my lord. 25 is the type portion, my lord. 25 the type portion.
What is your problem?
My lord, I've got spinal cord issues, my lord, basically.
Now that is common.
Yes, my lord.
That the jail authorities will provide for you.
My lord, I had a tumor in my spinal cord. So, my lord, I'm undergoing this electrotherapy to reduce that tumor, my lord. And if I don't take that electrotherapy treatment, my lord, my entire body shiver.
Where were you arrested?
My lord, in Assam, my lord, Naharkotia.
Where are you a original resident of?
Naharkotia. My lord, yesterday we have paid an amount of rupees 50,000 to the complainant, my lord.
Yes, Mr. Tom.
4 lakhs
Offense-
he has taken.
My lord, we'll
That
pay.
this is not a money recovery suit.
Yes, my lord.
Yes, your
Money-
lordship,
You have made your submissions?
Sorry,
Sit
sorry.
down.
Sorry.
Yes.
here, in this case, there was a promise to provide JCB service. And for that, complainant has an advance money of rupees 4 lakhs.
Hmm.
Then transaction corroborates the receipt of amount by the accused. And they were not responding to the police under section 41A, capital A of CRPC, notice twice.
Now,
Telephone-
in the second case, okay, we got it. In the second case, item number 18,
Yes.
has he appeared before the
As
IO.
per IO, he has not appeared. As per IO, but as per the accused applicant, he appeared, but IO denies to accept the bail bond.
May I kindly submit here, my lord? If my lord would
where
kindly.
is your affidavit in the second case?
My second case, my lord, IA, my lord. Item 18, I filed one IA. If my
Where is
lord-
that?
Yes, my lord. That is not.
I
It is not come on record, perhaps, my lord. But in that, my lord, I have stated that, my lord, I had gone there, my lord, to comply with the order, the 22-5 order passed by this honorable court. Thereafter, my lord, the IO said that 1 lakh surety amount was given with one surety. My lord, I had taken my surety along with me, Mr. Manjeet Singh. But the IO said that you have to mandatorily pay that 1 lakh rupees bail bond amount. We are not going to accept the surety. Whereas, my lord, the practice is that if surety is given, then that amount is not mandatory, my lord. I ventilated those grievances in the IA, my lord.
And as per status report, accused is not cooperating.
Huh?
Accused is not
No,
cooperating
my
with the
lord,
IO.
the IO
Both
is showing
accused.
high-handed actions of
But
the
here
IA.
it's very clear, execution of a bail bond of rupees 1 lakh. Money is not with one surety.
No, my lord,
You take instructions on that IA.
Yes.
He has filed an IA today. Have your instructions on that.
my lord,
How can I? I have to have a counter from them that you appeared. He did not accept.
my lord.
The counter is that you have not appeared. Let him give me his clarification. Then we'll see. We'll have it tomorrow. Or on Monday. Monday.
Huh? My lord, tomorrow.
No, Monday. He'll have to have his instructions.
My lord, actually, my lord, I am undergoing viral fever.
That's why I said you take 2 days rest, come back then, Monday.
13th.
13. Monday, Tuesday, Thursday, Wednesday, whenever it's comfortable. When?
13th ki hoga, 13th.
Thursday.
Uh,
12, Wednesday.
My lord, 13th.
13. And this one?
My lord, additional affidavit, my lord, I have filed. My lord, actually, my lord, what had happened is that we had actually applied for bail, my lord, before the Naharkotia court, but that was left, that was not appended in the bail application, my lord, due to inadvertence. So, my lord, it was not in our knowledge, so we have appended it, my lord.
Or you do one thing. You ask the IO, call him that they have filed an IA. What is his response to that? Come back at 2.
Yes, lord.
We'll have it today.
Yes,
Today.
2 days.
I am deeply obliged.
Yes, Mr. Lord.
Lordship. Lordship, on previous occasion, CD has been called.
But
You've got-
I
uh,
didn't receive note.
Why?
Deputy Commissioner sent what,
No, this is getting serious.
Lordship. Before the Larned Trial Court also, Lordship, my bail application was rejected despite of not s-
When were
submitted.
you arrested?
I was arrested on Lordship 16/4/2025. And till today, it's been 58 days, Lordship. On previous occasion, I have moved bail before the Larned Trial Court. But in that case, that bail application, CD was also called for, but was not produced by the IO. Despite of that, my bail was rejected, Lordship. I have enclosed the CD, rejection order. And today is 58 days, Lordship.
28,
58 days
58 days.
in custody.
And
Lordship,
charge sheet not filed.
No, Lord.
And
Bail was
maximum is 60.
60, because offense is punishable 5 years.
Lordship, his bail was rejected only his insistence, Lordship. Since he was not there, she does not fair.
Because CD was repeatedly not produced by the IO. And in that case also, the time was given to the IO for production of CD, but time after another, Lordship. That's why I made an insistence.
Wait.
I leave it.
Heard Mr. L. K. Leonard Counsel for the petition. Also heard Mr. D. Louis Leonard, public prosecutor appearing for the state respondents. Also, the present application has been instituted by the applicant praying for grant of bail under applicant invoking the provisions of section 483 BNSS 2023, praying for grant of bail to the accused Sri Rafiq Ali, who was placed under arrest on 16/4/2025. "58 days, how? 16/4 only.
Lordship,
How 58 days?
on 16/4, I was arrested.
16/4.
May today, Lordship,
15/5 is
I have wrongly calculated, Lordship.
Mr. Loy, Leonard Counsel for the respondent, for the Leonard public prosecutor submits that he be granted time till 11/6/2026, by which date he shall invariably place before this court the up-to-date scanned copy of the case diary. Full stop. Prayer accepted. Registry to list this matter again on 11/6/20.
Lordship.
I was about to give you.
Yes, Lordship. Lordship. I'm extremely sorry, Lordship.
My lord, the bail in the motion it says, my lord, where your lordship has granted the absolute bail. Your lordship, actually, prior to the registration of that FIR, there was a missing report. And basing on that missing report, your lordship, this
I did not give bail here.
you're in motion, no, the same, your lordship, one, this counsel, Mr. Tama, where he appeared. It is connected with this case.
Okay.
Your lordship, in this case, subsequently that FIR was registered, which the pre-arrest bail has been granted. Here, your lordship, prior to that, there was a missing report. And basing on that missing report, the family member of the girl was summoned by the police. So therefore, your lordship, this is not at all maintainable. Because it
There
was
is an FIR now.
now FIR.
File it against the proper FIR.
Yes.
This was against
Missing report, my lord.
Missing report.
Your lordship, this is the missing report, your lordship.
and what is the present case now?
Present case, your lordship, is against the wife of the
Not against him.
against her daughter, your lordship. The applicant was the daughter, your lordship.
And who is Dawa Mizi?
Brother,
Brother.
of the Ellie's accused.
So what do you want? Do you want to withdraw it and file?
Yes.
The learned counsel for the petition submits that. What is the latest case number, new case number?
Latest case number is, my lord, the SEPA WPS number 9 of 25.
Submits that he be permitted to withdraw the present application with liberty to prefer the same against the appropriate case registered by the police, by the SEPA police, by the SEPA police of the SEPA police station. First, prayer is not objected to by Mr. Ete, learned additional public prosecutor. Accordingly, the present application stands closed with liberty to the petitioner to file appropriate application as prayed for. Full stop.
1920 same, my lord.
1920.
Same.
19
19 and 20
19 and
same.
20.
19 and 20.
20.
Yes.
Okay, Tama's case.
Yes, yes.
That,
my
that
lord.
we granted.
Yes, this is, they are the, your lordship, the mother
Opposite
and brother.
They are the other side.
No, your lordship, mother and brother of the accused person, girl, that lady.
Okay.
Having with, there was an appear by the
We are music.
complainant husband.
DB response.
Oblige, your lordship.
That was item number, no.
3. Oh, 6, sorry, my lord, 6, item 6. Item 6.
Asha music.
Yes.
एक सेकंड आइटम नंबर 6 का फाइल दीजिए AB
AB 77.
that is against 9.
Yes. Yes, your lordship.
है
Which has been registered now.
9.
Yes, your lordship.
Okay, you file it. We'll get
Yes.
you have a order now.
Yes.
9. Okay.
Oblige.
Done. 20 also closed.
May I, Your Lordship? Your Lordship, in this matter, we need to get additional instruction from the department, Your Lordship, so some more time may be needed. Here we have filed our counter affidavit, Your Lordship.
My lord, this application has been filed for amendment of the board is
But you have
autonomous.
filed your, madam, you have filed your affidavit here.
Yes, Your Lordship, so
Then-
we need some additional instruction, Your Lordship.
What is the correction you are seeking for?
Seeking for para
Correct.
7 of my affidavit.
Of the writ petition.
No, of counter affidavit. Counter
You are appearing for the,
for the respondent to entry.
okay, you are not for the petition.
Yeah.
Who is for the petition? You want to correct autonomous as statutory.
Yes.
Fine. Paragraph,
Para 7, my lord. Para 7
no,
of
in the affidavit, which paragraph?
Annexure 1, my lord. Annexure 1. Page 28. Page 28, my lord. May I read, my lord? The Arunachal Pradesh University is an autonomous university. This should be a statutory university, my lord.
Okay, just a moment. Where is your affidavit?
My lord, Annexure 1. Annexure.
Your respondent number?
2 and 3.
When did you file this affidavit?
Yesterday, ma'am.
Huh?
Yesterday.
No. The original affidavit. when did
Uh,
you-
Last year, ma'am.
Last year.
Yes.
Where is it? It's not here on record. दूसरा और कोई affidavit नहीं क्या? Oh no, it's here. Page 27.
Yes, 28 and 78.
Is an autonomous university.
Yes.
Only this much.
Yes, only autonomous should be.
Only one word.
Yes.
But the petitioner is not here.
Yes. We have solved the copy.
The present interlocutory application, IAC, 143 AP 2025 has been filed by the respondents by the Arunachal Pradesh University, that is the respondent number 2 and 3 in the connected writ petition, that is WPC number 305 AP 2025, praying for correction of the word autonomous, horu apostrophe vitor, appearing in line number 3 of page 28, which is in continuation of para 7 of the said affidavit filed in the matter by as apostrophe statutory. Full stop. The said rectification as sought for has been noted and would be considered when the would be accordingly considered when the matter is taken up for final consideration. Full stop. I to read petitioner, none appears for the petitioner on call. However, the learned counsel for the respondents are present. Ms. So-and-so, learned counsel appearing for the state respondent submits that she be granted how much time?
2 weeks time.
2 weeks time to Ms. Pangu, 2 weeks time to complete her instructions in the matter. Post of prayer is accepted. Registry to list this matter again after 2 weeks. We have noted it. When it is finally taken up for hearing, we'll provide for that. Don't worry.
My lord, line 3 and 9.
Line 3 and line 9 of page 28.
Yes, 20.
Continuation of para 7.
That's it.
Yeah, 22, 23. 23, 24. Yes, ma'am. What is your instruction? Oh. Tara, you have already retired.
Yes, madam.
So, what can we do for you then? And the other one, he is getting the minimum.
Yes, madam. This is only recently from May onwards.
You did not know that last time also. Now you know about it.
Yes, madam.
He gave you a copy.
Yes, madam.
So what is left here? With regard to the second case, I can do nothing because he's already retired. After retirement, I can't give you retrospective regularization.
Yes, madam.
And with the other case, in view of the division bench order, my hands are tied. I can't go beyond the division bench order.
Yes, madam. I
That-
leave it to my lord.
Hmm?
My lord may dispose the matter.
But dispose the matter how? Dismiss it. Huh? Yes, madam, you want to argue, make your arguments.
Well, I humbly believe, my lord, in terms of this order 19 March 2025, my lord, his grievance has been taken care of, my lord. So this become infectious, my lord.
Where was that order of my Lord Justice Bodhakur upholding your regulatory scheme? Huh?
Filed by the respondent number 2, 3, and 4.
Page 116. These are similarly situated persons.
My lord. English state.
लिखे WPC 463 AP 2019. Mr. Pramay, madam, we will follow this to judgments and say that your pay has now been regularized in terms of that latest notification. So accordingly, we find no grievance exists. It's painful, but can't help it. The present
Prayer was,
for regularization.
yes.
Like, I can't do it.
It is
I can't do it. That order regulatory scheme has been upheld by the learned single judge. It has upheld by the division bench also. Can't go. I'm only a puny judge now. 2 judges bench when they've laid down an order. And the law is even a coordinate bench order I cannot go against. I have to follow. That is judicial discipline. Okay. But Madam Ganamniji, learned counsel for the petitioner. Also heard Mr. L. Pramay, learned counsel appearing for the state
Respondent number 2, 3, and 4, my lord.
Standing
1,
Counsel Power Department appearing for the respond number.
2, 3, and 4, my lord.
Ms. Pangu appears for respond number
1, Your Lordship.
1. Also, the present writ petition has been instituted by the appellant, by the petitioner, praying for a direction upon the respondent authorities to prepare a scheme to verify and consider the case of the petitioner for regularization of his casual service as a one-time measure. So, the petitioner in the writ petition has projected that he was initially engaged as a casual linesman in the office of the executive engineer, SEPA Electrical Division, when
1993.
in the year 1993 and thereafter has been rendering continuous service in such capacity with the respondent authorities. Also, it was projected in the writ petition that on the date of filing of the writ petition, the petitioner had completed more than 25 years of service. Also, the respondent authorities on receipt of notice have filed their affidavits in the matter, and therein have placed reliance on a decision of the coordinate bench of this court in the case of Taing, T-A-I-N-G, Taring and others versus State of Arunachal Pradesh and others. Judgment and order dated 7/2/2018 in WPC number 55 AP 2017, wherein the coordinate bench of this court noticing that coordinate bench of this court considering similar grievance raised, considering grievance raised by similarly situated persons like the petitioner hearing for regularization of their services, had upheld the memorandum dated 23/11/2016 by which What is that 23/11/2016, Mr. Permit? By which, by which the regulatory scheme prepared by the respondent authorities for regularization, for induction into regular cadre of casual, of employees employed on, of persons engaged on casual basis was upheld. Full stop. Full stop. The said decision of the coordinate bench was carried upon appeal. What is this appeal number? Was carried upon appeal in WA number, by way of instituting a writ appeal being WA number 4 of 2018. So the division bench of this court, on considering the issues arising in the matter, was pleased not to interfere with the decision rendered by the coordinate bench of this court in WPC number 55/2017. Full stop. However, the division bench proceeded further and examined as to whether the petition or the appellants therein would be entitled to a better pay package. Full stop. Accordingly, following the decisions of the Honorable Supreme Court applicable in the matter, had directed that where is that final conclusion? With the following observations, okay, with the following
The
observations.
direction, my lord, will by page 91, my lord. This
Huh?
is the direction, my lord.
Para?
Page number 91, my lord. 91, my lord.
9(1).
91, page number 91, my lord. What's the direction, my lord?
Direction of?
My lord, sir. Yes, my single bench. That was, this was the direction of single bench, my lord.
No. Where is that direction of the learned division bench?
Division bench retreated, my lord. We need to
That
carry
is
out that,
only.
my lord.
No, Jagjit Singh was brought in.
Jagdish Singh, my lord, yes, ma'am. Jagdish Singh was also in brought over at page number 19, my lord. This was the single bench direction, but that. No, हमको single bench का complex करो.
Jagjit Singh, my lord, will find in para 10.
Of the so, क्या लिखा है? However, the learned division bench had noticing the decision of the Honorable Supreme Court in the case of State of Punjab versus Jagjit Singh reported in 2017, 1 SSC 148. Also upheld the directions passed by the learned single judge in this connection, passed by the learned single judge. Madam, where is that order? I was just referring to my Lord Justice Botakus, WPC 55.
Page number 104.
There was nothing with regard to payment of wages here. In another case,
Page number 91.
91. Upheld by this division bench, उतना करके छोड़ दीजिए. Full stop. Full stop. It is also to be noted that another coordinate bench of this court in the case of, where is that page?
Start from 69.
In the case of Ijum Nomdir and 60 and others, while order dated 17/1/2017, passed in WPC number, above bracket mein hai, order dated so and so, comma, WPC number 482, bracketed AP 2011, had directed that in the event the petitioners therein are not found to be eligible for being considered for being regularized, comma, a determination is required to be made as to whether they are performing the same nature, comma, quality and quantity of work as is being performed by a regular employee working is the same oblique corresponding post. It was further provided that if upon such determination it is found that any of the petitioners therein is performing the same nature, comma, quality and quantity of work as is being performed by a regular employee working against the same corresponding post, such of the petitioners therein are to be paid their wages at the minimum of the pay scale as are being extended to the regular employee holding the same post. So, Mr. Pame has submitted that in terms of the directions passed by this court in the case of Nongdir so and so, a fact-finding committee was constituted, and the service and the nature of services rendered by the casual employees, including the petitioner herein, was considered. Also, thereafter, the government what was the fact finding with regard to the petitioner? What What is the fact finding against you?
There is no fact finding.
Okay, what happened thereafter, after the fact finding?
Fact finding committee said that, my lord, as per the report, my lord, my lord, did not, they are not appointed under the sanction post, my lord.
It was
And-
found that the petitioners were not appointed against any sanctioned post.
And they-
However, it is submitted that the government in the government of Arunachal Pradesh in the finance department, by order dated 19/3/2025, had revised the wages payable to the unskilled and skilled contingent employees of the casual workers of the laborers of the ALCs employed in various departments of the government with effect from 1/4/2025. Also, it is submitted by Mr. Pame on instructions that the petitioner herein is being released his wages in terms of the said order dated 19/3/2025. Also, Mr. Pame has further submitted that as of 31st March 2025, there are 4 vacant posts in the work charge establishment, and the said posts would be so filled up by following the prescription in the regulatory scheme. Also, the case of the petitioner would be so considered for regularization of his services in the event he comes within the zone of consideration for such.
But, my lord, here, my lord, he is from other trade, my lord. This vacant post is from other trade, my lord. There is no post vacant about where this petitioner.
Okay, continue. Mr. Pame has further submitted that as and when vacancies arise within the trade of the petitioner hearing, his case would be considered provided he comes within the zone of consideration, considered for regularization of his services, provided he comes within the zone of consideration. Also, in view of the above developments taking place in the matter, this court is of the considered view that the regularization of the petitioner as prayed for in the present petition cannot be granted inasmuch as the same would be governed by the regulatory scheme which has already been upheld by the coordinate bench of this court in WPC number 55 / so and so, which was affirmed by the division bench in writ appeal number so and so. Writ appeal number so and so. Also, in view of the above position, the present petition stands closed. Now come to the second one. Now what to do here? Yes, madam, what to do here?
Can only pray for retirement benefits.
You can't.
Yes. Relieved from work.
Yes, only get terminal benefits, nothing else. And he had also not come within the zone of consideration. But Miss so and so, for me, kabhi likh dijiyega. The petitioner in the present proceedings has prayed for a direction upon the respondent authorities for preparation of a same prayer. For preparation of a scheme to verify and consider the case of the petitioner hearing for regularization of his services, of his casual service with the respondent authorities as a one-time measure. Full stop. The petitioner was initially engaged in the establishment as a casual chokidar in the establishment of the executive engineer SEPA Electrical Division in the year 1991, and thereafter has been discharging his duties in the said capacity till date. Also, it is to be noted that the regularization of services of casual employees engaged in the power department is governed by a regulatory scheme of
2004.
The regulatory scheme of
9/12/2004.
Who's up? Mr. Perme, Mr. Perme on instruction has submitted that the petitioner, not having come within the zone of consideration for his zone of consideration for Mr. Perme has submitted that the seniority position of the petitioner had not facilitated consideration of his case for regularization under the said scheme inasmuch as against the vacancies coming into existence from time to time, the petitioner had not come into the zone of consideration. Also, it is submitted by Mr. Perme that the petitioner was released from his services on attaining the age of superannuation with effect from 31/3/2025. Full stop. In view of the fact that the petitioner has already proceeded on superannuation with effect from 31/3/2025, this court is not in a position to direct for retrospective regularization of the petitioner's services for the purpose of facilitating drawal of pension and pensionary benefits by him. Full stop. The regulatory scheme dated 9/12/2024 having been approved by on a challenge being presented to the regulatory scheme dated 9/12/2024 and such challenge being negated by the coordinate bench of this court in WPC number 055 Uparme and the same being affirmed by the division bench of this court in WA number so and so, the regularization of the petitioner cannot be directed to be made in violation of this said scheme. So in view of the above position and also in view of the above position and considering that the petitioner had superannuated from his services with effect from 31/3/2025, this court is of the considered view that no further direction, considered view that a direction for regularization of his services would not be now mandated to be so that issued. Further, the case of the petitioner cannot be considered under the regulatory scheme of 9/12/2024 after 2004 after his superannuation from service. So, accordingly, the present writ petition stands dismissed. However, there would be no order as to pause. Sorry, madam, can't help it.
I will listen.
Yes.
Item number 26 may be taken up first, my lord, and consequence will follow the item number 25, my lord.
May I please, Your Lordship, I beg to pray that this item may be passed over for time being, Lordship, because the conducting counsel, Miss Jeet, she is engaged in court one.
See, ma'am, the second half, we have a lot of orders to deliver. So it will be difficult. You can have it on a hearing day then, some other day. I think I heard this matter on the last day. I heard this matter, I suppose.
No, madam.
No, I'm not heard it. Oh, it was adjourned.
Adjourned.
It is with regard to some LPC.
LPC, yes, cancellation of LPC.
It will take some hearing. Tell me when. Mr. Tama, when? He is here. You both are the people who start missing. When?
2nd July, my lord.
Oh, that will be too far away. Mr. Sonar will have to check up.
No issues.
As agreed to by the Learning Council for the parties raised, but that would be a last week. We'll not put it there. That would be a motion week maybe. We'll not put it there. Because just a week before vacation, put it a week before that. 22nd or 24th, whenever it's, you're coming on 24th.
24, 27.
27.
27 of June.
27.
We'll have it on
26th, my lord.
26. 26. Okay? 26. As agreed to by the Learning Council for the parties, raised it to list this matter again. on 26/6/2025 for hearing. Pleadings are complete now?
Yes,
The
pleadings
records are also, no? Okay, fine.
Highly obvious. Okay.
खत्म नहीं है. The list is over. You give me those files, and let me just go through it. 13, 14. And 16, 17, 16 and 18. Just give me those files. You give it to me. Item number 3. Yes, item number 3. Yes.
This application is file under section 442. Section 520.
Just a moment. Madam, this will go in item number 21. And this will go in item that last item, which I just disposed of, permanent item. 3. Item number 3. Yes.
This petition is filed for recalling the.
This is not for recalling. You dispel this view that I have gathered.
Yes,
This is for delaying.
No, Lordship.
6 years, 7 years, you wait. You change a counsel, and now you want the witnesses to be called back because they made some contradiction in their 161 statement.
Yes, Lordship.
Show me the law. Show me the law. I'll allow it.
Section 348.
There are Supreme Court decisions. There is a decision of mine also.
Yes, Lordship. However, I have also relying on one judgment.
Show me that. That is the issue. Nothing more.
Yes, Lordship. This is the judgment.
Because those two witnesses were examined in 2016 and 2018.
18, yes, Lordship. Yes, Lordship. In this judgment, Your Lordship, the Supreme Court held that even after the even after completion of the evidences, the Honorable Court has the power to recall the witnesses.
This is on a different context altogether, Mr. You have examined him. He was examined, you cross-examined him.
Yes, Lordship.
Then he was released.
My Lord,
Now if you have to bring him back, you will have to have, we can't, this is 311 is not to fill up the lacuna.
Yes, Lordship.
Then
my Lord, we have not, we are not going to fill up the lacuna.
you
However,
have,
we have
whatever is there, argue.
My Lord,
What is 161? 161 is only for refreshing and corroborating.
yes,
Then
yes. For that contradiction, my Lord, in 161's statement, if Your Lordship go through the 161 statement for once, actually.
Where is the PP? Call the quick PP को बुलाइए. जिनी एटे किसी को बुलाइए.
Lord, we have filed that petition, recall petition.
Okay, show me what is the inconsistency.
Your Lordship, at page number 16, Your Lordship, the victim.
Just that portion which he has
And
said
your-
excess or not.
12/3/2013 evening, I along with my two other friends and Sri Rahim Ali gathered at Sankey View Tiniali, where my father has 3-4 shops and in which I was planning to open a shop in a room. All of them suggested their own view, and finally we decided that a Xerox machine shop will be profitable at that place. Since in that night there was hot weather, so we came out from the shop and were sitting in Sankey View Tiniali. But around 11:30 p.m., one local boy, who later identified as Longfutake, reached to the spot and started arguing that why we were sitting at night. Late night, and when I replied him that my residence is just behind the shop, that person got angry and started quarreling with us. Since it was a late night, so we decided to get dispersed from that place. Subsequently, after half an hour, my two friends went to their home, and I, along with Rahim Ali, left for my residence. But the same person again arrived in Yamaha R15 bike
white color having armed with a dao and challenged us. Since that he was a very violent, so we ran away towards the residence. But the said miscreant started chasing in his bike and ultimately attacked with a dao on my neck in front of my residence on the roadside, which I protected him with my left hand. But he again attacked on my face, and I have this time with right hand. Since Sri Rahim Ali was shouting my parents, so the miscreants fled away from the spot in his bike. After the injury, I got unconscious and fallen in my campus while proceeding to my residence. However, if your lordship go through the
He has
evidence
denied
part-
that the accused, he has seen the accused or accused was the person who was.
Yes,
That is the thing. Who are you?
My lord, I am the accused petitioner.
You are accused petitioner. Then it goes in your favor.
My
Page
lord-
25. Yes, Mr. Loy. Page 24, 25.
24, 25. However,
Come to
on-
the cross.
Yes, your lordship. Earlier, this case was
Okay, he identified you. And what material inconsistencies?
my lord, the material
This is not
inconsistency is that
164.
Lordship, purpose was for opening of the shop only. The kind of shop, the Pangumti or Xerox Dukan, yes.
My lord, earlier this case was taken by some state defense at 8 council.
Whoever it is.
Yes, lordship. However,
But
if your
it-
lordship go through
I'm
the
not satisfied.
my lord, if your lordship go through the evidence cross-examination part, your lordship.
This is not a 311 is not for filling up a lacuna.
My lord, yes.
Supreme Court is very clear on that.
Yes, my lord.
What
Yes,
is
my
your
lord, I
decision?
understand it, but
What
but
is
the
your
thing,
decision on that now? What was the decision you were trying to rely upon?
Rajendra Prasad, your lordship.
Where you have given me a copy?
Yes. I have just given the copy.
Can the trial court permit lacuna in filled up? The conventional concept is, but then what is meant by lacuna in a prosecution has to be understood before deciding.
The last paragraph, your lordship.
I'm sorry. Anything more?
My lord, kindly
You want
appreciate
to,
me, your
you
lordship.
want to argue the matter? It's very easy. I have a judgment. I'll just get it. But I'm not satisfied.
My lord, the thing is
And
that
the
section.
learned trial court has correctly come to the conclusion.
Well, we are not going to fill up the lacuna. Moreover, the thing is that, my lord, whatever the
You
cross-examination.
cross-examined him. You can't have a re-cross-examination.
Earlier, at that point of time, some state legal aid council has cross-examined the victim as well as the independent.
And
witness in
the
connection with this
learned
case.
trial court had also taken note of decisions of the courts. Where
Yes,
it
yes.
says that change of counsel is not a ground for.
Yes, lordship. We have filed a said recall petition for the ends of justice, my lord. At least he shall have
Ends
the
of
right.
justice. Ends of justice.
As per the provision itself, your lordship, under section 348 of BNSS, your lordship.
That was the basic thing you had to do.
Yes,
That
lordship.
was the basic thing. Contradict him. This is your 161. 161 can be used only for that purpose.
Yes, lordship. However, at that cross-examination part, your lordship, the state defense, state legal aid council did not contradict the statement recorded
Your
in
name is not,
161.
your name is not reflected in the cost title.
Yes, lordship.
Not
Because my name was not recorded here, so.
You have filed a wakalatnama.
Yes, lordship. And moreover, your lordship, on the last part that we have filed this petition.
Mr.
for
Roy?
the ends of justice. your
Mr. Roy?
Yes, lordship.
I'm adjourning the matter today.
Yes, lordship.
Take your chance. On the prayer of the learned council for the parties, for the petitioner, Mr. Roy, raised it to list these matters again. After, when? On. Give me a date.
Any fixed date, your lordship.
Huh?
Any fixed date, your lordship.
No, you give me a date. 9th, Monday?
Can I check?
Monday, Tuesday, whenever it's possible. Date le lijiyega unse. So let him have a chance.
Yes, sir.
Let him argue.
Oh, nice. My lord, in item number 27, we have been informed that in item number
27, 28, it's connected matters.
connected,
It is fixed on when?
9th of this.
Ah,
Your
any
Honor,
problem?
my lord, there is a urgency in item number 27
Ah.
because their prayer was for stay of the proceeding of the
Have it on
appeal.
9th, it's only on 9th only. We have fixed it
My
on 9th.
my lord, this is the time for harvesting, and because of this interim protect order passed by this honorable court, my entire LPC land, the agricultural land,
See, we
I
have
bar from
to-
entering into
We
entering my
will have
agricultural
to
land.
hear both the matters together. One, then in Dicky Punning, I think is leading the other case. In the other case, he's also not there. So
Yes.
we said on 9.
My lord, I am only agree by the
So you
interim
want
order.
a hearing today?
Yes.
Huh? Okay,
Yes.
get it.
But can it be 13?
13, 13. Yes.
Much obliged.
Call the other parties also. Order recalled. You're for the respondent.
No, he's for the petition. I am for the respondent.
Okay, let's see the interim order. 20, kitna tha? And tell who is there in 28 also. Inform them. We'll have it at 2 o'clock. First item. Inform the other side. Right?
Okay.
What is your case?
Lordship, my case is that I am possessing a plot of land measuring about 16,000 square meter at a particular village. The said land has been encroached by the respondent.
Hmm.
I have filed an case before the village authority. Village authority has taken up the matter for hearing without my presence. As per section 44 of
Then what happened? After the order, what happened?
ex parte order.
Order, what happened? Have you not challenged it?
Yeah, I have challenged.
Where?
I have challenged before the civil judge senior division.
Then what happened?
And the civil judge senior division has passed a status quo order with respect of the order passed by the village authority.
Then?
Again, the status quo order has been challenged by the respondent before the district judge in the concerned district. Up,
By way of filing an appeal?
yes, by way of filing an
Okay,
appeal.
now tell me.
Lordship, my submission is that they could have filed a revision under 115 of CRPC. They have wrongfully filed the appeal.
How
before.
can a second appeal be maintainable,
Yes.
Mr. Counsel?
That is my case.
And the district judge has passed an order?
Yes.
That is your case?
Yes, yes.
Yes,
And
I heard this matter.
With agreed with the.
I heard this matter.
Yes, yes. On the
Ah.
last date, I have.
Uh-huh.
made a submission.
Yes, how can a second appeal, DHOS section 100 be filed?
My lord, there is the difficulty.
You are urgency, we'll allow the.
Yes, yes.
We will hear it today.
Yes.
2 o'clock. You inform the other side. What is item number 28 is only connected. It's not the same matter. The issue is same. 28 we can segregate.
Yeah, yes, we can say.
We can only hear 100.
Yes, yes.
Huh? We
Because
can only
if
hear
we-
27.
If we club 28, then the main council of 28 may
Is
not
not
be.
there.
Yes, it may be segregated. No,
It's not the same land, separate.
not different land.
Different land. Issue is same. That's why we had it together.
I'm not aware of 28. but
My
it
lord,
may be-
where not.
Mr. Dilip Mojumdar was supposed to argue this matter
No,
today.
no. In that case, Dilip Majumdar.
Other case, huh?
Yes, yes.
So we'll adjourn that case. We'll hear in
Yes,
case at 2 o'clock.
Yes.
But you satisfy me how a appeal before the district judge is maintainable.
Lordship.
That much only.
Lordship.
Okay?
Lordship.
Yes, the urgent civil matter first. Oh. Mr. Chetia, your matter we had disposed of yesterday. Today it is being it will be uploaded. It is wrongly shown as CAV.
Lordship, yes.
It was already ordered. Okay,
Lord.
the other matters I am giving it today.
My lord.
Diji.
Obliged.
One, who is the bench assistant is there? Papuri is there? Etu ek number to bhulke goise de. সেইটো মই অলৰেডি ডিসপোজ কৰাই দিছো 29 তাৰিখে অৰ্ডাৰো আপলোড ইয়াতে নেটৰ প্ৰব্লেম হৈ আছিল কাৰণে আপলোড হোৱা নাছিল আজি হৈ গৈছে ঠিক আছে 2 3 4 হে দেখাব খালি item number
Item number 27.
give me the orders just 2 judgments I'll deliver The writ petition stands dismissed. Usko. Writ petition dismissed. The impugned assessment orders are interfered with along with the notice issued under section 40. Demand notices as well as the notice both interfered with. However, we have directed that your assessment is held to be complete, and under section 40, if the department still has that limitation period, they can take whatever steps they want to take. Okay? You will have the order by tomorrow or day after, it will be uploaded. There is some problem here in uploading, it will be uploaded tomorrow or day after. But otherwise, the writ petition is allowed, disposed of. 27. First this one.
My lord, what has happened in this case is that in a land dispute,
No, let us come to the meat of the matter. There was a Kebang decision
yes,
which was challenged by him before the learned civil judge
the
senior division. And the order is at page 18, right?
yes,
Status quo order.
status quo. order.
Against this, what did you do?
We file an appeal.
Okay, now you show me how that appeal is maintainable. Because that would be a second appeal. Okay, where is it?
Section 15 subclause 2, an appeal. 15 subclause 2, an appeal from the decree or order passed by a court of civil judge senior division in an original suit and proceeding of civil nature shall, when such appeal are allowed by the law, lie to the court of district session of that district or in the court of additional district judge where such court exists or the high court as the case may be. So your
So
lordship,
this order was passed by the civil judge senior
Civil
division. And 15.2 says that if it is permissible under law, then you can file an appeal. 3 forums have been given. Now you show me which is the law applicable, which permits an appeal from a first appeal, a further appeal before the district judge.
my lord, it is silent in this act.
Silent, you have the code because you come to section 2,
Subclause, yes,
section 2C.
subclause C, define the code.
Code means the civil procedure code. Right?
Yes, Lords.
So civil code means these are the codes. So now you tell me, this is in form of section 100.
Second appeal.
Second appeal. How can a second appeal lie before the district judge? Educate me on that. And you take your order.
My lord, there was
When I
a-
adjourned the matter, I
Yes.
thought this issue would require a deeper consideration. Mr. Majumdar would be there, Panning would be there. So everybody, you all together, we can give it a closure. I wanted it to do it today, but today they are not here, so I did not.
Actually, lordship, we have a urgency in.
Okay, you
Dear,
argue.
dear prayer in
I'm
the.
going to, then I'll have to hold
Yes.
that this appeal that you have filed.
Their prayer in the appeal was for conduct of de novo trial, and we are not shying away from conduct of de novo trial. We are also
Mr.
ready.
Counsel, here I am only concerned with the order passed by the district and session judge in an appeal before him. from another appeal filed by the court in the court below, which is in the form of a first appeal. Second appeal would lie before this court. You have filed it before the district judge. Show me it is maintainable. Take the order. That is the only issue arising here. The forum. And you have not filed a revision petition. You have filed a appeal.
My
How
lord,
is it maintainable?
my lord,
And it says 3 forums in accordance with law. Law is section 100.
my lord, in that case also, if our appeal is not maintainable, though it appears to be not maintainable, then, my lord, this matter may be remand back to the trial court.
Fine. If he agrees,
Appeal, yes,
You
from the
agree?
day
To
one, from the day
to
one.
the trial court, your status quo order
Yeah,
will be
appellate court.
continuing. We'll do that. You agree? Make a statement. We are doing that. Do now or
Yes, Your
immediate-
Honor, from the
I'm doing
day,
it now only.
from the day one, we have been frank that we are ready for the de novo trial. And this
No,
matter
no. It will not be a de novo trial. It will be
before the appellate court.
before the appellate court.
Yes.
This order, which was now interfered with by the district judge, this order dated 11/2/2025, we would interfere with.
Yes, sure.
Huh? This,
Yes,
that
sir.
will revive the order dated
26/11/2024.
26/11/2025, right?
Yes, Your Honor.
You both,
My lord.
you both appear before the civil judge
Yes.
senior division, take the matter forward.
Yes, my lord.
Agreed?
For early disposal of it.
Agreed?
I am agree up to the extent of hearing the appeal before the,
That's it.
yes.
The
Yes.
order which is there, that will be revived, that's all.
In the meantime, we can fix a short date and appeal for. There also, we have nothing to say only. We are
We-
ready for the de novo trial.
The petitioner, by way of instituting the present proceeding, has assailed an order dated 11/2/2025 passed by the District and Session Judge Pasigar in appeal case number 3. 3, na? Appeal case number? What is the appeal case number?
Yes, free of, yes.
3 of
2025.
2025. Full stop. The said, full stop. The materials brought on record would go to reveal that against an order passed by the Kabang, by the jurisdictional Kabang, the petitioner herein had approached the court of the learned civil judge senior division Pasigar by way of instituting appeal bracketed civil number 28/2024 assailing the same. Also, the learned civil judge senior division Pasigar, while order dated, where is that order?
Last.
Order dated 26/11/2024. Huh?
11/2/2025.
That is the order of the
Session.
district judge. The order of the
26/11/2024.
26/11/2024, while allowing the respondent therein to file his affidavit in opposition objection to the IA, had directed the parties to maintain status quo with regard to the suit land. It was further clarified that no party shall be permitted to carry out any further construction, cultivation, or enter into the suit land till the next date fixed. Also, being aggrieved by the said order dated
26/11.
26/11/2024, the respondent hearing had assailed the same by way of filing appeal number 3/2025 before the court of the learned district judge Pasigar. Full stop. Right? The district judge Pasigar while order dated 11/2/2025 on consideration of the issues arising in the matter, was pleased to issue notice therein with further direction that the order dated 26/11/2024 passed by the learned civil judge senior division Pasigar with further direction to keep the order dated 26/11/2024 passed by the learned civil judge senior division Pasigar under suspension until further order. So accordingly, the petitioner hearing has instituted the present proceeding. When the matter was taken up for hearing, Mr.
T. Sunil.
P. Sule, learned counsel for the petitioner, has fairly submitted that the appeal as instituted by the sole respondent hearing before the district judge Pasigar, that is the appeal number 3/2024, would not be maintainable and accordingly 2025 would not be maintainable and would be in violation of the provisions of the Civil Procedure Code. Full stop. Accordingly, he submits that this court would be pleased to interfere with the order dated 11/2/2025 passed by the district and district judge Pasigar in the said in civil appeal number 3/2025 and remand the matter back to the court of the civil judge senior division by maintaining the order dated 26/11/2024. First off, he further submits that the sole respondent has urgency in the matter and accordingly the civil judge Pasigar, civil judge senior division Pasigar be directed to expeditiously consider and dispose of the said appeal. First off, they said prayer made by the learned counsel for the sole respondent is not disputed by the learned counsel for the petitioner. He submits that the order dated 26/11/2024 passed by the learned civil judge senior division be maintained till the disposal of the appeal pending in the said court. Also, I have considered the submissions made by the learned counsel for the parties and on noticing the consensus reached by and between the parties in the matter, this court proceeds to set aside and quash the order dated 11/2/2025 passed by the district judge Pasigar in civil appeal number 3/2025 on the ground that the same was passed without jurisdiction. Also, accordingly, the civil appeal number 3/2025 also stands dismissed. Also, in view of the above interference made by this court with the said order dated 11/2/2025, the order dated 26/11/2024 passed by the civil judge senior division Pasigar would stand revived. Also, the parties are directed to appear before the civil judge senior division on
9th.
9th is to
Monday.
Pasigar, na?
Yes. My lord,
On tomorrow morning 10:30. Tomorrow, a copy आज ही upload हो जाएगा. 10:30.
Tomorrow.
10:30 tomorrow.
Lordship,
Still there.
Lordship, currently the judge is on transfer. He is not even at the station. There cannot be any
It can be
urgency.
fixed on Monday, 9th.
Judge is not even in a station.
11/6/2025. Full stop. It is provided that full stop. The learned civil judge senior division Pasigar is requested to expeditiously consider and dispose of the appeal being appeal number the appeal being appeal bracketed civil number 28/2024. Full stop. The interim directions passed by the appellate court on 26/11/2024 shall continue till the disposal of the said appeals. Full stop. With the above observations and directions, the present revision petition stands disposed of. Done.
Lordship, there is one more to be added, Lordship. There is one more order. There is 19/3/2025.
Where?
That I have filed that in my additional affidavit dated 30.
Passed by the?
Passed by the district and sessions district court Pasigar.
What is the date of that order?
19/3/25.
Where is that? Which page?
There is page number 133. 130. Additional affidavit I have filed.
Additional affidavit है क्या? What is the name of your party?
The same name, same party. Page number 133.
There is no 135 here.
What's that?
Oh, there is 135. Just a minute. Just a minute.
133.
Just a minute. Just a minute. ऊपर में लिखा है ना आपने 11/2/2025 ने क्या है? And other any other orders passed in the said proceeding. That will look because I've set aside the civil appeal.
My lord, what has happened in this case, in the IA, after getting the stay order of the civil, passed by the civil judge senior division, we were allowed to do agricultural activity on my agricultural land.
Now you go.
Thereafter, we were doing an agricultural activities. Now, thereafter, one day, this respondent brothers and his son, they enter into.
File a police case.
We have filed a police case, FIR case.
File a case. Now that you can't file the civil suit because civil violation is not there because I've interfered with the order. Go before the district judge, before the civil judge, senior division, and finish off the matter. That's all.
Yes, madam.
Why keep these things pending?
Lordship, that specific order may be given. Lordship, specific date. That order dated 19/3/25.
Along with order dated 19/3/2025 passed in IAC number
IA number 16/25.
16/2025. Huh?
Maybe.
ऊपर में एक बार
Yes. Yes.
ठीक.
Yes.
Much.
Now you go and finish it up.
Yes.
Deep your
No. One. Only one has been. Item numbers were 28. 28 will, item number 28 will लिखिए. List this matter again after 2 weeks on a date to be fixed by the registry. क्या उसमें हम पहले कुछ डेट दिया था क्या इसमें? और 9 तारीख को लगा this matter again on 9, huh? As agreed to by the Learning Council for the parties. 28. No, ठीक है. Next, busy.
Yes, Lordship. Yes, Lordship. This my ground for application, this bail application is for that. The accused person is a medical patient and suffering from the hepatitis since.
They are not providing you treatment.
No, your Lordship, actually, in the.
You were taken to TRIMS also for that.
Yes, yes.
Then
now he needs a regular checkup because the hepatitis is a communicable disease and it is unsafe and harmful for the other prisoner in the.
Yes, madam. What do you say?
Lordship, may go to the charge sheet, Lordship. Where it is prima facie well established, Lordship. That's why it is placed before the honorable court. But it seems that trial has not been begun yet. And this is as for the offense is serious, Lordship. So.
Okay, where is that FIR?
Yes. FIR is Lordship, page number 13 to 15 is the FIR.
13.
Yes. Lordship, in the FIR, this page number 15. In the FIR, there is no name of the accused person has been mentioned because this FIR was lodged by the brother of the deceased.
Okay, come to page 15.
Yes.
Now, what is the material against you? The charge sheet.
The charge sheet is there, Lordship.
Lordship, in the page number, charge sheet number, in the page number 59, here is one witness, eyewitness. She is Janam Martam.
Just a moment, just a moment, so
Yes.
just a moment. What are the names of the accused here?
Yes, Teni Baja. And,
Tani Baja.
And Yanyak Baja. Both are husband and wife.
Yanak.
Yanyak Baja.
Yannick.
Now, have you gone through this thing?
Charge sheet, Lordship.
Hmm?
Yes, Lordship.
Yanak Muttam is who?
Yannick was Tani.
Yanam Muttam?
Yes, he is
Yana-
the eyewitness.
Yani Motor, she was the one who informed that this accused parents bought Tani.
No, where is the material
Yannick.
against these two?
Lordship, here, Lordship, material is that, Lordship, the statement, Lordship, statement of the Lordship, accused Jotin Kapak, and well as that, Lordship, there is this statement of the eyewitnesses is there, Lordship, Yalva Gyate, Yami Gyate, and Kete Yate also there, whose statement also been recorded 180 BNSS.
Where is that statement, that confession statement?
Lordship,
183.5 of Yanam Muttam, age 25, Tabam Mugli, wife of Tabam Mugli. That's one.
Miss Yani Motem.
Yani
Yes,
Muttam. Well, let me just check up.
Yani Montem is the one who informant, Lordship, who informed us that night to the accused both parents, Lordship, that is the accused Tani Baja and Srimati Yannick Baja.
No,
She
till
informed-
now, I have got the material that they came to the place of occurrence, but they were involved in the assault. Where is that material?
Lordship, it is here, Lordship, on the basis of statement of co-accused Jotin Kapak and other several circumstantial witnesses, Lordship, it is under para, Lordship. Then
How long have you been behind the bus?
Yes, Your Honor, the affair was on the 7th of March, Then but I was arrested on the 15th this April after 1 month. Now it is almost 51 days as of now. Now, if we count from the FIR, now till this charge sheet, it is 88 days. And Lordship, actually, I was not intend to involve in this incident. My boy, this now who is a juvenile in CCL, he was fighting with the deceased person. Because he was bitten by the deceased. Then I involved in just to prevent the fighting. I have no any intention that I should beaten of this the disease. And Lordship, if you go to the statement of the Jyotin Gapak, who is the co-accused in this case, and he is the eyewitness in the case. He has stated that the IO has asked him about who has used the bricks on this accused person.
See, the statement of the victim is, before his death, he had implicated you.
Lordship, in the statement of the Jyotin Gapak, who is co-accused, he has stated that the bricks used by this one accused person who has put this bricks
No, a non-accused means maybe in the FIR you are non-accused, but the material show that you are involved in that transaction. You had hit the father had hit the boy who had subsequently expired, and the mother also.
Lordship, being a pardoned mother, we have no intention that we have.
But that boy is gone.
Yes.
And charge sheet is there. Where is the trial?
And Lordship, the accused person, the two children are still living alone in the house, and no one is there.
Yes, madam. Custodial interrogation is not there. There is no apprehension that they would be fleeing from the.
That statement has already been recorded.
Recorded. Now, what is there? Let them face the trial.
Lordship, then, yes, Lordship.
We'll give some condition.
Then Lordship, if Lordship is willing to give the Lordship protection, then strict condition may be imposed, Lordship.
Yes, Lordship.
The present application has been instituted, praying for bail for enlarging the accused Ani Baza on bail in connection with the Purijok Police Station case number 18/25 under section 117 bracketed 2, 103 bracketed 1, 3 bracketed 5 PNS corresponding to what is the GR case? What is the case here? It has not been committed now. Till now.
It is.
Charge, it has been committed by to the court of the session judge.
CGM Lordship, before CGM, the statement been recorded, Lordship.
No, was it committed for trial?
Trial, Lordship.
This is the latest remand order by the CGM.
That is, I have not go through, Lordship.
Okay,
Only we have
committed
received
to the court of.
In the record, we have received the CGM court Lordship that charge sheet they have submitted. That order I have not been received yet.
16. Full stop. Corresponding to GR case number 18/2025. Full stop. It is seen that while order dated 1/6/2025, the court of the Chief Judicial Magistrate Tapurijo had committed the case to the court of the honor, the court of the learned additional session judge Basar for trial. Charge sheet file ke likha hai na? Materials brought on record would reveal that the investigating authority, after completion of investigation, had corresponding to GR case number 18/25. Full stop. The investigating agency, on conclusion of the investigation, has filed its charge sheet in the matter against the present accused person under section 103 bracketed 1, 117 bracketed 2, and 3 bracketed 5 PNS 2023. Full stop. The learned CGM Tapurijo on above the Tapurijo wide order dated 1/6/2025 in view of the fact that the accused was also charged under section 103 bracketed 1 of the BNS 2023 has committed the case to the court of the learned additional session judge Basar. Also, I have perused the materials brought on record in the present, I have perused the scanned copy of the charge sheet produced before this court. Also, on perusal of the materials brought on record, this court is of the considered view that further custodial interrogation of the accused is not called for, and there is no apprehension raised by the investigating officer of the petition of the accused fleeing the process of trial and or delaying the proceedings in the trial, inasmuch as the accused is a resident, permanent resident of the area of the district itself. What is that district?
Yes, Kamli district.
Kamli district itself. So, in view of the above position, this court hereby directs that the accused so and so Tani Baza be enlarged on bail, regular bail, on furnishing a bail bond of rupees, to the satisfaction of, it will now be the district, district and additional district.
Yes, district court.
To the satisfaction of the additional session judge Basar.
Yes.
Subject to the following conditions. वो trial attend करेगा without fail. No intimidation of the conditions. Any other condition you want to incorporate?
During the proceeding, lordship, the trial proceeding, he may not be, lordship, instigate the other witnesses.
No, that is there. That is there.
And he may be
He shall invariably attend the trial court.
whenever called for, lordship.
He shall not remain away. He shall not remain absent from on any
He should
day
not leave the
during
court, leave the jurisdiction.
he will not be absent from the on any date of the fixed in the trial without prior permission of the trial judge.
Additional session.
Of the additional session judge Basar. Full stop. The petitioner, baki wo ek hi hoga, shall not threat, abuse, wo jo paega tha, wo dekhe. With the above observations and directions, the present bail application stands disposed of. Next wala mein.
Next.
Is the wife, lordship?
Yes, same case.
Tapar Baza hai ye, wo hoga, nahi, ye tapping, what was the name? Sorry. Tani Baza ye, and ye wala hoga, Srimati
Yani Baja.
And lordship, he may not be, he leave the jurisdiction of that place. lordship.
He will not leave the jurisdiction of the additional session judge, learned additional court of the additional session judge Basar without prior written, without prior order of the.
Lordship, he's staying not there, Basalo, he's staying Kamli.
Yes, yes.
He's native,
Okay.
he's staying in other place, lordship. Basa is the, lordship, court jurisdiction, lordship.
So petitioner shall not leave his residence.
Yes, lordship.
Yes.
His residence, same district,
Yes, same district.
shall not leave the district of, what is that district?
Lordship, it's a Kamle district.
Kamle district without prior permission of the,
Lordship, IO of that, lordship.
no,
OC of
additional
that,
session
lordship.
judge Basar.
Yes.
And lordship, that is, yes, lordship. That will be.
It comes under that
Yes,
jurisdiction.
lordship.
Yes.
And next wala hoga, madam, same thing, khali wo naam change hoga. Yaniak, YANIAK Baza. Srimati Yaniak Baza.
Yes.
ठीक है? Disposed.
Right.
Obvious, deeply obvious. These scan copies come physically or they scan it and send it in the mail?
Lordship,
This-
that is, lordship, the registry will give answer.
How
lordship.
does it come? It comes mail, it comes in the mail.
This is a photocopy,
But this is wastage of
yes, lordship.
paper. We'll have to find out some way to look at it in the,
Yes,
it's too much of it.
nowadays, lordship, all these lordship.
Oh, this comes.
Lordship, digital lordship, yes.
Who is there in 16?
In 18.
Have you got your instruction?
Yes.
What?
IO didn't, yeah, he informed me that this applicant was not ever never present before the
Okay.
PS.
Okay.
And one advocate was present on his behalf. Applicant,
Okay. Okay.
but he
fine.
was told about the orders, interim
was told.
orders.
Ah.
He was told.
But if the accused
But
is
he
not there,
never
you can't
appeared
pass it
again.
on. Okay,
Yes.
fine, no problem. We'll do the needful. Which is that item, Mr. Sharma?
My lord,
Which is
the
that item?
anticipatory bail is 18.
18 video.
My lord, may I kindly submit something here, my lord?
What?
My lord, what my senior friend has just stated.
It is all, of course, you went there, you did not do it. He did not allow you to
Yes,
record.
ma'am. Yes.
I'm giving you the solution for that.
Yes, ma'am.
Just wait, give me 2 minutes.
Yes.
This court, full stop, heard Mr. P. Sharma, learned counsel for the petition, and also Mr. G. Tadu, additional public prosecutor appearing for the state. Full stop. This court, while order dated 22/5/2025, had extended the benefit of interim pre-arrest bail to the petition, to the accused applicant, Sarbajit Singh Virdi. So it is the contention of Mr. Sharma, learned counsel for the petitioner, that in pursuance to the said order dated 22/5/2025, the petitioner had appeared before the investigating officer for execution of the bail bond, as well as for recording of his statement in terms of the directions passed by this court. However, the IO had refused either to execute the bail bond or to accept or to record his statement. So, Mr. Tadu, on instructions, have submitted that the accused had never approached before the IO. However, an advocate representing the accused had approached the IO along with a certified copy of the order.
Orders.
So, be that as it may, this court directs the accused to appear before the investigating officer on 10/6/2025 at what time? 10:30?
Yes.
At 10:30 a.m. For some, the IO shall thereafter record the statement of the petitioner and also execute the bail bond as mandated by law by adopting a procedure mandated by law. Now, there is an interim application on execution of bail bond of rupees 1 lakh. Why is it to give 1 lakh? Bond is to be given. Instructed. Yes, when a bond is there, you
Yes,
need not give the money. A bond will do.
Yes, the surety like amount.
Surety is giving. One person will go as surety. The person is asking for the cash equivalent of 1 lakh. Inform.
It is, Your Lordship, as per order, it is with surety.
With surety, one surety of
1
like.
lakh amount. Here, normal practice is like this. Yeah, money has to deposit, and one surety has to put sign on the bond.
Bond only. Money is not required.
Money is here. Practice is that money is deposited.
Your practices, you reform. Your practices, you reform it. Tell
Yes,
your
sir.
IO, he'll come, record his statement. First off, thereafter, the investigating officer shall forward a scanned copy of the case diary along with the statements recorded of the accused applicant to the learned additional public prosecutor, Mr. G. Tadu. First off, Mr. Tadu shall place before this court the updated scanned copy of the case diary as received by him from the IO of the matter of the case on the next date of listing. Registered to list this matter again on
The 13th, my lord.
13th. Or we'll ask him to go on 10th. We are when 10 दिया ना मैडम 10 को जाने के लिए बोला ना then 13 ठीक है
10th की date.
Yes. CD में repeat.
CD the case diary produced by Mr.
My lord, Tuesday, my lord, I'll be, my lord.
You are not required. The accused is to go.
Oh, yes, ma'am. Yes. Sorry.
If you keep going, how will the IO record? will he record your statement?
No, my lord,
Then
my lord,
ask your petitioner to go there.
my lord, may I kindly have 1 minute? Actually, my petitioners, they had gone there, my lord. But the IO categorically
Okay,
refused.
establish that. Call your petitioner. We'll have a cross now. We'll cross it.
No,
Okay, call your petitioner. Within 10 minutes, ask him to come.
no, my lord,
Mr. Sharma, be reasonable.
Fine.
I have neither accepted your nor accepted their.
Yes.
I can't even ignore the IO. Why should the IO say a contrary thing?
Yes.
And at the same time, why should I disbelieve you?
Yes.
How can I come to a conclusion? Should I come to a conclusion in that?
no, my lord.
You appear, record your statement, come back, we will finish it off.
Yes.
The case diary produced by Mr. Taduk is written, and an updated one as directed above would be produced on the next date of listing.
It was 16, my lord.
The interlocutor IA criminal 47/2025 in view of the orders passed today in WPC number in bail application number so and so, the same no further order is called for in the present IA, and the same stands closed. And now what is it? We are finished with Sarvajit. Now Baljit. Yes. What is this? What is the material against him?
My lord, same, my lord, offense of cheating only, my lord,
Okay.
420, my lord.
You get your statement recorded.
My lord, he's in
On the
custody.
next date of listing, we will consider this together.
My lord, he's in custody, my lord.
But that's it.
Interrogation has been done. my
Hurry, you go one of you go, the other one, let him go.
My lord, may I submit one more thing, my lord?
Hmm.
Yesterday, my lord, we had already paid an amount of rupees 50,000, my lord, to the
Hmm.
complainant, my lord, Ajahar Karimar. I have the record, my lord, if I may kindly place it, my lord. We are trying to show our bona fide, my lord. And there is a statement made in
Yes,
the bail application,
this
my
is a
lord, that
case
we are
of
ready to return the money, my lord, within 6
22,
months.
23. And the incident took place on 18,
then
FIR was
17.
22. 3 years required to pay back the
This
money.
is not a money suit. Criminal case is not a money suit.
Yes,
He had committed an offense.
if they voluntarily
Okay.
pay back, then it can be quite.
I'm allowing him to go. We'll put some conditions. Hmm?
Yes.
Because basically a civil dispute. Basically a civil dispute. Why should be what custodial
Evading police arrest is something pointed towards criminal ingredients.
Naturally,
of-
there is a criminal incident indicate here, but the basic allegation, if you read, it is with regard to the non-payment of the money against the hired thing.
Yes, yes.
So that is a civil dispute. But because maybe he has been running away, not cooperating with the informant has filed it. You have arrested him. You have taken his statement. Now let the criminal case take its own course. But why is his detention, custodial detention, going to improve the case other than bringing a pressure on him to make the payment? That cannot be. Okay?
Yes.
But Mr. P. Sharma, Learned Counsel for the petition for the applicant accused. Sri Baljit, full stop. Also heard Mr. G. Taduk, Learned Counsel, appearing for the Learned Additional Public Prosecutor, appearing for the state respondents. Mr. Taduk has placed before this court the case diary in full stop. The present application has been instituted by invoking the provisions of Section 483 of the Bharatiya Nagarik Suraksha Sanhita 2023, praying for enlarging the accused Sri Baljit Singh Virdi on bail in connection with Chimpu PS case number 86/2023 under Section 420 and /34 of the Indian Penal Code. Full stop. The petitioner, the accused, full stop. The informant in the FIR in the matter was lodged by the informant on 22/11/2023. And the same was registered as Chimpu PS case number
86.
86 of 2023. Full stop. The allegation leveled against the accused is that the accused had defaulted in providing for JCBs on higher basis in spite of having taken advance amount for the same in pursuance to an verbal agreement entered into by the between the accused and the informant in the matter. Full stop. The money advance money was stated to have been so received by the accused in the month of July 2021. Full stop. So, in pursuance to registration of the said case, the accused was arrested on
My lord, he was arrested 12, my lord, 12/5/2025.
12/5/2025 and thereafter is in detention. So, I peruse the case diary as produced by the learned counsel for the by the additional public prosecutor and find that co-accused has already been granted interim bail by this court. Co-accused Sarbajit Singh Vurdhi has been already granted interim bail by the coordinate bench of this court in AB number 72/2025. So, considering the nature of the allegations leveled against the accused person and also the fact that a co-accused has already been granted the privilege of pre-arrest bail, this court is of the considered view that the petition that the accused herein, accused so and so, क्या नाम है उसका Baljit Singh Vurdhi is entitled to be enlarged on bail in connection with Chimpu PS case number 86/2023 under section 420/34 of the IPC on furnishing a bail bond of rupees 1 lakh to the 1 lakh along with one surety of like amount to the satisfaction of the, it will be CJM UPR to the satisfaction of the CJM Capital Complex UPR. Full stop. Subject to the following conditions. वो आगे माला में जो लगा है कि he shall appear before the he shall appear before the Ayug as and when called for. 1, 2, he shall not destroy evidence नहीं करेगा. 3, he shall leave the jurisdiction of the learned CJM UPR only after receipt of written permission from the court. Is that required? No, he should remain here. He is not required here. और last वाला कर दीजिए. बाकी लगा.
My lord, on humble prayer, my lord, the surety amount, if it could be reduced.
1,50,000.
My lord, no, my lord, 1 lakh, my lord. I am deeply obliged.
1,50,000.
My lord, 1 lakh.
And if you want, you take cash, no problem. So, you dispose of.
My lord, humble request, 1 lakh, my lord, 1 lakh. I am sorry.
You anticipatory bail 1 lakh. Regular bail, it should be 2 lakhs.
No, my lord, I am sorry, my lord, 1 lakh.
No, 1,15,000.
No, my lord.
Any more, one more sentence, it will be 2 lakhs. So 1 lakh. Mr. Sharma, know where you have to stop.
Sorry.
That's one of the best things you got to learn in advocacy. Court has given you maintaining parity. Otherwise, there will be a fight in your house. Two brothers, both of them say, you got 1 lakh, I am getting 30,000. What is this? Everything should be clear. Okay, fine. All right. Khatam. Thank you.